number 42, the people of the state of New York versus David Mendoza. Counsel?
Good afternoon, Your Honors. I'd like to request 2 minutes for rebuttal.
You may.
Good afternoon. My name is Caitlin Halpern of Counsel for Appellate Advocates, and I'm here on behalf of David Mendoza. Mr. Mendoza was deprived of meaningful representation when his trial attorney conceded guilt on all counts, abandoned legitimate defenses, and advanced only a jury nullification defense.
So, counsel, what would, if we agree with you here, what would our rule be going forward? How would trial courts deal with this?
The rule we're requesting is that nullification defenses constitute ineffective assistance of counsel when there's a legitimate defense available.
So let's say these circumstances, this defense counsel gets up, says, the people's case is airtight or rock solid. This is a rock solid case.
Rock solid case.
Prosecution now has to object. Objection, they characterize my case as a rock solid case.
And in fact, the prosecutor here did object.
To rock solid case?
Not to rock solid case specifically, but to some of the other remarks.
So what happens? Objection. What happens?
So there are two different things that could happen. One, as Your Honor points out, the prosecutor could object, and the court should sustain that objection. That's what should happen under this court's case law anyway.
So then
but
the defense
trial court
lawyers
can also intervene.
I'm sorry. Defense lawyer then keeps going. Objection again. What happens?
The trial court should continue to sustain those objections because a nullification defense is an illegitimate defense as clearly established by this court's precedent.
You qualified the rule as you stated it by saying when there is a legitimate defense.
Yes, Your Honor.
So what happens when there is not one?
First, I would say that that is a much more difficult question that this court does not need to reach today.
What was the legitimate defense here?
There were two possibilities that we discussed in the briefings, and perhaps a creative attorney or judge could come up with something else. But we said that there are two mens rea defenses that the trial attorney could have raised. One, that Mr. Mendoza was not aware that he was not allowed to enter the building, and or two, that he didn't enter with the intent to steal. And as this court recognized in Duffy, evidence of mens rea is almost never conclusive. There's rarely direct evidence of mens rea. There's usually something that an attorney could say.
So can the trial judge then call a sidebar in the middle of the defendant's summation and say, what else you have?
I suppose it could, Your Honor, but what would be better is...
Do you think that's a good rule?
I think a better rule is for this court to clearly say that nullification defenses are not permissible, instead of adopting the people's rule that would create that kind of scenario.
One of my favorite court movies is a movie called The Verdict. I don't know if you're familiar with it.
I'm not, I apologize.
Go back and watch it then afterwards. All of us would recommend it to you.
How old are you?
To all the lawyers in the courtroom, all right?
How old are you? Don't answer.
It was one of Paul Newman's last movies. Anyway, part of the argument in there, the case itself, you could argue, results in nullification. So when I was reading this case, I was thinking about it, and I thought to myself, the danger in what you're proposing is you're proposing a no mercy rule, and that if it isn't objected to, that the court has to make a determination on it. So it scares me a little bit, and I would never want to set up a situation where a jury couldn't exercise the right of mercy. And let me give you two examples in the context of this case. First, here, I would find it very difficult to accept an argument of nullification since this person was convicted to the top charge. In other words, nothing was nullified. There was no nullification here. The jury didn't act that way, so there was no actual jury nullification. The second thing is when I went over, I read the summations again and various parts of the trial testimony, and it strikes me that a fair argument could be made that this attorney was really arguing for the lesser included offenses. In other words, this is a petty larceny, Your Honor. He's being overcharged. And even the detective himself, Your Honor, thought the case was being overcharged. Those are fair arguments to make in this case. But that's not the same as asking for a rule from us which would arguably restrict a jury's right to exercise mercy.
So two things, Your Honor. And first, respectfully, counsel was not asking for a compromise verdict. In his own words, he said, I am not asking you to find my client not guilty of burglary.
But the more important point is, do you understand the consequences of such a rule? If we should implement such a rule in this case, which is an overcharged petty larceny.
That's right, Your Honor, but there's no reason to be afraid because we're not asking for anything that this court has not already decided time and again. This court, more than a century ago in Duffy and more recently in Weinberg and Getz, held very clearly that nullification defenses are inappropriate.
No, we
because
didn't hold that. What we held was you're not entitled to argue it. So if there is an objection, and I think in Weingarten they got an instruction, one there's objection. If you're prevented from arguing it, you can't say that's error because you're not entitled to argue it. But that's a very, very different question. You get the defense by, which may be your most effective defense. Are you going to be held to an ineffective assistance of counsel standard? We have never reversed a conviction based on that.
But what you have held in your ineffective assistance of counsel cases is that a defendant is entitled to a well-grounded defense that is accepted by law and a strategy that is legitimate.
So let's talk about that, though. You seem to be basing your entire argument on a summation. I don't think we've ever said it, but I think appellate division courts have said you don't even have to sum up. That's not ineffective. So don't you have to look at this entire record to see what the argument was, not pull one statement out of a summation?
Absolutely, Your Honor. And the opening, every cross-examination, and the summation show that the only defense advanced at all was nullification, a defense that was foreclosed by the jury instructions, and then left appellant with no defense at all.
So is your claim of ineffective assistance that they gave up a potentially successful strategy, or that they admitted guilt and that wasn't a successful strategy here?
Concession of guilt was certainly problematic because it went against the client's interests. He was advocating against his own client's position. But the other piece of it is that nullification is impermissible because it doesn't provide the jury any way to acquit. Once the jury says once the judge says, you must take the law whether you agree with it or not, there's no defense. And some defense is better than no defense, even if it's not winning.
Is your rule, as you stated it when you first stood up and opened, apply even if the defendant says that they are in agreement with this approach?
That's correct, Your Honor.
Fully understand the approach, they understand the consequences of it?
Under Colville, that's a tactical question for the defense attorney, not for the client. And again, the problem
Let's say the defense attorney decides, I'm going to present it to my client. If the client doesn't want to do this, I'm not going to move forward with it.
We would still maintain that when there's a defense with some basis in law, counsel is obligated to pursue that defense and not abandon those defenses in order to pursue a defense
Well, what
that
does
has
that
no
mean?
chance of
Every
success.
potential defense? If you don't pursue every potential defense?
Any defense that has
no matter how marginally colorable? You're
I would
ineffective?
say similar to the standard used when deciding whether to submit a lesser included. If there's a reasonable base in the evidence, if there's some evidence, and that's the standard that the 10th Circuit applied in Capps and that this court should apply here.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court, Gamaliel Marrero for the respondent. Your Honors, the order of the appellate division should be affirmed because here counsel was effective. In the face of overwhelming evidence of guilt, defense counsel pursued a reasonable strategy of conceding guilt on the petty larceny count and seeking to persuade the jury that a conviction on the burglary counts would be unfair in light of the circumstances of the case, such
Did he
as...
attack the elements of the crime in his summation or in his opening or during cross?
In his summation, he did make an argument as to the elements of, as to the defendant's knowing unlawful entry into the building. He made an argument that the people failed to show that the no trespassing signs were posted on the front of the building on the 2 dates that the defendant entered and stole the packages. That was the extent of his argument as to the...
That they weren't visible on the videotape?
That they weren't visible on the videotape. He suggested that the signs were not posted.
Counsel, going back to, I think, something Judge Fahey said, kind of the gist of that, which is this case kind of raises some very troubling issues in ways. You're in the courtroom, prosecutor's hearing, and arguably a nullification argument. It seems to me there's always a plea for mercy in most summations that I've heard or read. Prosecutors generally tend to let a lot of that go because you don't want to be jumping up in front of a jury and saying, objection while they're accusing you of being oppressive, right? So it's a very delicate balance, although technically there's no right to argue that. What troubles me, I think along the lines of this, what Judge Fahey was getting at in terms of a mercy defense, is a rule such as the one your opponent is arguing for would make it much more of give much more of an incentive for a prosecutor to jump up and object when anything is arguably straying into nullification territory.
Right, and in this case, defense counsel's summation could reasonably be construed as a challenge to the sufficiency of the people's proof, such as arguing the facts don't fit the charges, while in one context, yes, defense counsel was arguing that they don't fit in the sense that there was no break-in, there was no damage to property. It could also reasonably be construed that he's arguing that the people failed to present their, or meet their burden of proof. So yes, Your Honor, a rule such as the rule that my colleague here suggests.
But how's that when he starts out saying it's a rock-solid case?
I'm sorry, Your
More
Honor?
than once. How is that? If he says more than once, it's a rock-solid case.
Well, he was saying rock solid case as to just to the theft of the packages. You know, when you take comments like it's a rock solid case, there's no mystery here, out of context, yes, they can be seen as conceding guilt on all counts. But viewing the opening and the summation in context, bringing those comments in context, defense counsel was clearly arguing that there's no mystery that David Mendoza walked into the lobby those 2 days and took packages, but that he did not commit a burglary. That was the gist of defense counsel's argument. He was not conceding guilt on all the charges.
Could he, well, that's interesting, last point you made. Could he nevertheless be arguing as an alternative basis, mercy, nullification, whatever you want to call it? Could it be that both things are happening parallel?
Oh, sure, definitely, Your Honor.
Is that what happened here?
It appears to be the case, Your Honor.
Okay. All right. So why isn't he ineffective if he's then also arguing as this alternative basis, one that, as counsel argues, is not permissible?
Well, Your Honor, my colleague here relies on Weinberg. Weinberg doesn't stand for the proposition that a defense attorney may not, under any circumstances, pursue a nullification argument. Certainly, Weinberg says that the trial court can and should preclude nullification arguments, but that does not stop defense counsel from pursuing it, where the trial court has permitted it. So defense counsel here was not ineffective for pursuing.
Yes, but if the directive is to not permit it, isn't the consequence of that lawyers should not be, or defense counsel shouldn't be getting up and making that kind of an argument?
Well, Your Honor, defense counsel first introduced the argument opening statement. The court allowed it. The court continued to allow it. I think defense counsel, in weighing the risks and likelihood of success of different strategies, should be afforded the latitude to consider one argument or the other and pursue that argument which he thinks would, or he or she thinks would.
It's possible for an attorney to be ineffective even though the judge lets you be.
Oh, sure,
Right.
Your Honor. But under the facts of this case, defense counsel was not ineffective. I mean, it depends on the law, the facts and circumstances at the time of the representation. And here, viewing the record as a whole, counsel was not ineffective for perhaps emphasizing pursuing a mercy verdict a little more than, pursuing a challenge to the elements of the crime.
It seems to me in that case where we were saying you have no right to and you have an instruction, there the defense counsel was saying I should be able to do this. This is my best shot and I want to be able to do this in that case. And we said, no, you have no right to do this. The judge can tell you, you can't argue that. The judge can give an instruction. You have to follow the law. But it was what that defense counsel believed was my best defense. Here's almost the reverse. It's what this counsel, and I think supported somewhat by the record, believed was the best defense, let's say nullification. They wanted to do it, and they actually got it through when it could have been objected to and it could have been stopped. And I'm having a hard time fitting that within the framework of our ineffective assistance analysis. Because there's a defense counsel made a decision, this was a reasonable defense. The facts are, the evidence of guilt was very strong here, videotapes, and they could have been prevented from doing it legally, and the judge would have been sustained or would have been affirmed on appeal perhaps. But they got that defense through, still believing it's the best defense this defendant had on this record. And now the rule we're being asked to do is to say, and this becomes very tricky to me, to say you're ineffective for getting through a defense you believed and others have believed in the past was the most effective defense you could have because you shouldn't have been able to argue it. I mean, you shouldn't be able to argue, you have to prove my client guilty beyond a shadow of a doubt, but if you get that through, is it really ineffective? So, I have a hard time lining this fact scenario up, and it's troubling in ways with our ineffective assistance standard.
Well,
there's no question in there, but you can comment on that statement.
Well, I think the people aren't proposing a general rule. We're simply saying that under the facts and circumstances of this case, it was a reasonable and legitimate strategy to pursue the strategy that counsel ultimately chose. The defendant here cannot establish the total absence of strategic or legitimate explanations for pursuing, in the face of overwhelming evidence, what was arguably defendant's best shot at being acquitted of burglary in second and the third degree.
That's one of my questions. And I understand the quandary it puts the court and counsel in if in making a ruling, the trial court has to somehow know what the defense strategy is. So is this proposed rule that it may be okay in some circumstances but not others, is that really just for appellate review or?
Oh, no. I would say the question of whether an argument is okay or permissible or proper is different from whether that argument is ineffective.
Well, okay. So would you agree with me? See, I see Weinberg a little differently from how some of my colleagues see it, and I thought that the court, pretty clearly said that permitting counsel to raise a nullification argument or defense, I think the language was, would encourage to encourage the jury to abdicate its primary function, would directly contravene the trial court's authority to instruct the jury that they must follow and properly apply the law, which the trial court did here. So I see that, I read it as saying it's not proper for the court to allow it, and it's not proper for defense counsel to do it. Your argument is that doesn't mean that it's ineffective to do it? Well,
I would suggest that, yes, Weinberg does say that trial courts should preclude nullification arguments, but it doesn't say that defense counsel may never request it or pursue it if the trial court allows. But also, I'm sorry, I kind of lost the question, to be honest with you. But I would also just...
I was talking about the distinction between what we've said isn't proper and whether that constitutes ineffective assistance.
Right. My apologies. If I may, my red light is on. I'll answer quickly. Frankly, even if an argument or strategy is arguably improper, it doesn't make defense counsel's representation ineffective. For example, if defense counsel argues on summation that if he appeals to the jury's sense of sympathy or appeals to the public's mistrust of government to try to persuade the jury to impute some nefarious intent onto the prosecution, that in itself is arguably improper, but it's not ineffective. It doesn't deprive the defendant of a fair trial. That in itself would not deprive the defendant of a fair trial. In other words, even if a defense attorney's argument is considered impermissible or improper, that is not per se ineffective assistance. You've got to look at the full circumstances of the case.
Well, so that actually brings me to the thing that I want to know about, which is, can we really resolve this whole issue on a direct appeal in the absence of a 440 to know whether this lawyer had actually considered whether there were legitimate other defenses, was cognizant of the fact that he could argue, the absence of the requisite mens rea and whatever else could be explored on a 440.
Well, it's an excellent point, Your Honor, and I would say, yes, a 440 would flesh it out. For example, a 440 motion would possibly flesh out whether the defendant agreed with defense counsel's strategy. On the record, defense counsel says that, my client never really denied what happened here. He just thought he was being singled out and overcharged. A 440 might clarify whether that was defendant's position. But again, here, just looking at the facts of the case, what the trial court permitted the defense attorney to do, defense counsel was not ineffective. Defendant cannot establish here the total absence of a strategic or legitimate explanation for defense counsel's strategy.
Thank you, counsel. Ms. Halpern?
I'd like to briefly address two questions. And the first is whether the summation challenged the sufficiency of the evidence. And the answer is that it absolutely did not. As we discussed earlier, trial counsel never asked for a conviction on the lesser and an acquittal on the greater. He didn't even ask for the lesser included offense of trespassing. He never challenged a specific element, either in his presentation to the jury or in his motion to dismiss. Instead, he argued only that the jury should be fair because Mr. Mendoza did not commit the crime of the century. And second, why is this ineffective assistance? The reason is that trial counsel presented only a defense that was foreclosed by the instructions the jury is presumed to follow, therefore leaving Mr. Mendoza with no defense at all, when he could have had a defense with some basis in the evidence.
Okay,
Yes, Your Honor.
So that gets to my issue of, like, how do we know whether that lawyer really evaluated the legitimacy of these alternative defenses in the absence of a 440?
Right, and that's an important question, Your Honor, but not one that has to be answered to resolve this case, because we don't need to know what was in counsel's head. All we need to know was, did he choose a defense that is not recognized by law over a defense that is recognized by law? And the crux of the argument is that instead of pursuing a mens rea defense with some basis in the law that had a hook in the court's instructions, he chose to advance only a nullification defense, and that's clear from the face of the record.
Given your rule, your position is if indeed there is actually no legitimate defense, no other option, that if a lawyer makes this plea for mercy to the jury, prosecutor doesn't object, court doesn't stop the counsel, that then that lawyer is not ineffective?
Again, I think what a counsel is to do when there's nothing to say is a hard question that you don't have to answer. But yes, if there's absolutely nothing else to say, I would be hard-pressed to argue that it was
That's such a
ineffective
difficult rule
assistance.
to enforce. And going back to Weinberg, and Judge Steins was right about that language, if we do read that to courts essentially have this affirmative duty not to permit this, and the rule is, well, if you have nothing else, it's not ineffective, the court's going to now have to start really cracking down on nullification arguments. So you're making a nullification argument, there's an objection or the court's own objection to that because they can't permit it. Can you say, I've got something else coming later, so let me argue nullification now? I mean, I think it's going to really, careful what you ask for, have the effect of forcing judges and prosecutors to take a much harder line on appeals to mercy to a jury.
So this court has already very clearly established what a court is allowed to do. We're just asking for a small extension to clarify what counsel is allowed to do. But we know that the court cannot encourage nullification and has to sustain those objections, as it did in many instances here.
So what happens if the lawyer looks at the case, looks at the evidence, and just, and I've had this happen, has an obstinate client who just refuses to face the reality of what the facts and evidence show. Can that lawyer stand up and argue, instead of saying, it's a rock-solid case, as happened here, say something to the effect of, I want you to hold the people to the burden of proof. Is that going to be a veiled attempt at nullification?
I see that my
And
time has expired.
ineffective.
May I
You may
briefly?
continue.
So I think the defense you're outlining is a classic reasonable doubt defense to challenge the credibility of the witnesses, the sufficiency of the evidence, the quality of the police investigation. Those would all be legitimate defenses that are preferable to a nullification defense because they give something rather than nothing.
And what if you only do, as I think Judge Feynman is suggesting. You just say, hold the people to their burden, and then the rest of your summation is all about nullification and pleading for mercy.
As one of the judges pointed out earlier, you'd have to look to the rest of the case. So here, the cross-examinations were solely directed at interpolating elements that did not exist, establishing no break-in, establishing that the items were cheap. If other parts of counsel's presentation to the jury, say opening and cross, establish some sort of defense, that might not be ineffective. But if everything was about nullification, as it was here, that would have deprived the defendant of any meaningful representation.
Thank you, counsel.
Thank you, Your Honors.